Good evening and welcome to the East Lyme Board of Selectmen regular meeting of May 7th, 2025. We're in the Town of East Lyme Upper Meeting Room. We get to rise to recite the Pledge of Allegiance. Pledge of
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay, are there any additional agenda and consent calendar items this evening? Not aware of any. Are there any public delegations that would like to address the Board of Selectmen tonight? And if you would just identify yourself and give us your address, please.
I am Joshua Caskey. My address is 1 Grooms Way, East Lyme, Connecticut, and I'm here to urge you to not support the 830G moratorium. Connecticut and East Lyme as a whole are experiencing a severe housing crisis. We have seen this in our community through the tenants at Windward Village when they were forced to look for other housing, unable to find any unless they were on a wait list for 2 to 4 years. So they had to stay in a hostile landlord, in an apartment with a hostile landlord relationship, and wait for a fair rent commission, which was gladly a good thing it was approved. But that stress should not be put on them at any point for our seniors. We have also seen a third of our tenants, or a third of our citizens in East Lyme are cost burdened from housing, which means that they are making difficult decisions on whether to pay for housing or to pay for childcare or food or transportation, which is a very difficult decision to make, so we should not be putting that stress onto our citizens of East Lyme. So this is all caused by a lack of supply. We don't have enough housing. And this is part of what 830G is supposed to do. It's supposed to allow our developers to build the housing that is needed. And there is demand for housing, as we have seen with these, again, very high housing costs. So you cannot claim that we have enough affordable housing because of these conditions that we have seen of seniors being threatened with eviction, threatened with absurd rent increases, of the very high concentration of cost-burdened households in East Lyme. So there is a very severe shortage in East Lyme, and the only way we can solve that is to build more housing, and the 830G would help with that, and implementing a moratorium for 830G statute would directly oppose that goal, since our zoning commission has routinely rejected reasonable housing projects over the past several years that would help people stay in East Lyme and stay in a house that is affordable for them. Recently, our zoning commission chair stated that they are tired of Hartford telling us what to do. I am tired of our government pretending to care about affordable housing and continually blocking affordable housing in our community. I am tired of people like tenants at Windward Village worrying about where they will go if they are forced out by an exploitative landlord. I am tired of our government failing to provide the basic human right of housing to us. Applying for this moratorium is not a good way to solve this housing crisis. It will only further hinder our ability to build housing. And if you apply for this moratorium, it will just show that you continue to not value your citizens' rights to housing. So again, I just urge you to oppose this moratorium and to not apply for it. Thank you.
All right, thank you.
Thank you.
Appreciate your thoughts. Is there anyone else this evening that wants to address the board? Okay, seeing none, we'll move on to the approval of the public minutes. Approval of minutes. Do I hear a motion for approving the minutes for the public hearing of April 16th, 2025?
Move to approve the public hearing minutes of April 16, 2025 as submitted.
Do I hear a second?
I'll second.
Thank you. Any discussion? Any changes? Being none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Being none, motion carries. Do I hear a motion to approve the regular meeting minutes of April 16th, 2025?
Move to approve the regular meeting minutes of April 16th, 2025 as submitted.
Do I hear a second?
A second.
Any discussion on the regular meeting minutes? Being none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Being none, we move forward. Next is the consent calendar. Do I hear a motion to approve the consent calendar?
Move to approve the consent calendar for May 7th, 2025 in the amount of $375.78.
Okay. Not too controversial. Do I hear a second?
I'll second.
Okay. Seems like the regular type of items. All in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? Being none, that motion carries. Next, tonight we're going to hear a presentation on 830G moratorium, a discussion, and we have Attorney Tim Blaisdell here tonight from Walsworth and Palmer to give us the background of 830G. Thank you, Tim, for being here this evening. Appreciate it.
I'm happy to be here.
Great.
So as our first selectman said, my name is Tim Bleasdale. I'm from the Town Attorney's Office, Waller, Smith & Palmer. Excuse me. And I am here tonight to talk about the possibility of a moratorium on something called the Affordable Housing Appeals Moratorium process. And so what I'm going to do is give you a little bit of an overview of what the appeals process is for land use applications that involve affordable housing, to explain what a moratorium is, how we get it, and then to sort of talk through some of the consequences you might expect if we do get a moratorium. The Zoning Commission has spent about a year, a little bit more than that, studying this issue, and the professional staff down in the land use office, spent that time really combing through all the old records, trying to find documentation of all the affordable housing units that we have in town. And as a part of that process, we were able to determine that East Lyme can qualify for a moratorium if the town decides to apply for it. So I reported that to the Zoning Commission back in October, and they considered that for a little while, and I came back and gave them some more information about it. And then ultimately in February, at the end of February, they voted to make an advisory recommendation that the town go ahead and apply for a moratorium. And before I get into the weeds on this, because it can be a very dense topic, I just want to be clear that what we're talking about is not a moratorium on affordable housing itself. It's a moratorium on a special legal procedure that applies to these types of land use applications. And so to sort of understand what that process is, I think it's helpful to kind of start with what's the standard process for a non-affordable housing application. And I'm going to have to generalize because these rules apply to several different commissions, several different types of applications, but I'll kind of use a general example from the Zoning Commission. So if you have a non-affordable housing application that comes before the Zoning Commission, they basically have three options for how they're going to act on it. They could grant it with modifications, or deny it. And in doing that, they can premise that decision on a strict application of the zoning regulations. And what happens then, and this is where that appeals procedure would kick in, and we start down a different route if we're talking about affordable housing, but on a typical application, let's say it's been denied or granted with modifications, the applicant can then appeal to the Superior Court. And when they get to court, the applicant has the burden of proof to show that the commission basically got it wrong, that there was something improper or incorrect about the commission's decision, and the commission can defend its decision by pointing to a requirement that's in the regulation that the application didn't comply with, or something along those lines. And that's a procedure that is more favorable to towns and their regulations, because the town can strictly apply the regulations. What the Affordable Housing Appeals Procedure does is sort of turn that on its head. So when the zoning commission receives an application proposing affordable housing, they still have those three options of granting with modifications, or denying the application. But then, if an appeal happens and they've granted it with modifications or denied it, the appeals procedure for affordable housing shifts the burden onto the commission. So now they've got to go into court and prove that what they did was correct in the proper decision for this application. And the law doesn't just change who has the burden in court, it also raises the bar for the town. So in order to successfully defend the denial of an affordable housing application, the commission has to be able to specifically identify something in their record that establishes that there was a reason that they had to deny it or modify it that was necessary to protect a substantial public interest in health and safety, and that public interest clearly outweighs the need for affordable housing in town. That's an extremely high bar to meet in court, and towns almost never are able to meet that. And so what this has sort of led to is folks often say, zoning regulations just don't apply to affordable housing applications, just because it's next to impossible to prove that in court and meet that bar. And so that's what we're talking about with the affordable housing appeals procedure and how it's different from the standard process. Does anyone have questions at this point before I move on to the next bit? Yes, sir.
I have one. So they go and it goes to appeals, and they say you have to prove whatever. So does that mean something can still be built there, or does it not for 830G? Meaning that if somebody applies for affordable housing in a lot, okay, and they go, no, it doesn't qualify for affordable housing, can a regular house or something else be built there?
Yes, if I understand correctly, I think what you're getting at is if the commission denies an application for affordable housing, could the applicant come back and propose something different go there? And that's true.
Okay.
If they're pursuing an appeal, most likely they're going to fight it out in court and see what happens before they come back with another application. But one of the reasons why I kept talking about the strict application of zoning regulations is that because it's so hard to apply them to an affordable housing application, invoking 8-30G on a land use application often will allow you to build something that otherwise wouldn't be allowed to be there. Maybe you have more density in apartments, or you have an apartment complex going in someplace where under normal rules it wouldn't be allowed. And so that's why towns tend to look to these to try to be able to strictly apply their regulations.
And had a question?
Yeah, so I just want to make sure I got this straight. So with the non-affordable straight like housing application, the developer has the burden of proof. And then with the 830G, the town then has the burden of proof, is what you're saying?
When you end up in Superior Court, that's correct.
Okay.
Yeah, and because you kind of have to think it through. So technically speaking, that appeals procedure applies in court, but those cases are decided on what happens in this room when the zoning commission's meeting. So you kind of have to think backwards and already be applying it to some extent while you're acting and working on an affordable housing application. So it changes the whole nature of what happens at the zoning commission.
So are there any towns in the area that have passed a moratorium? And the second part to that question is there a lot of like appeals and lawsuits? Like how is this all playing out, I guess, if you know?
Every town's a little bit different. Across the river, Waterford applied last year, and I have a copy of their
I saw
application.
That.
Hopefully you didn't all print it. It's almost 200 pages, but I do have a hard copy here. If anyone wants to see it, I can leave it here.
It was emailed to us.
It was emailed.
Yeah, we saw the email.
Perfect.
Yeah.
Okay. It's interesting. Fairfield had recently had an experience that was very different from what Waterford experienced across the river here. When you apply to the state for a moratorium, there's a 90-day period where the state can review the application, could ask for more information, but the state gets 90 days to decide. And during that 90-day period, any application for affordable housing that's applied for during that window continues to get the old rules. So even if it's still the application is still pending while when the moratorium is granted, they still get the benefit of the old rules. And that's a standard rule in land use. And so in Waterford, they applied, and they were not inundated with applications for new applications for housing. But it's been reported in the Connecticut Examiner, for example, that down in Fairfield they experienced the opposite. So that they published their notice that they were going to apply for this, and developers wanted to take advantage of still being able to invoke 8-30G for a little while, and they started submitting tons of applications. And the figure that they cited was that there was 300, or more than 300 new affordable units that were proposed during that period. And that sounds like a lot, but I think it actually is an understatement of what probably really happened there, because these affordable housing projects tend to be a mixture of market rate and affordable. So the mix tends to be about 30% affordable and 70% market rate, because that's what the statute provides as the minimum. So when you do the math on that probably means that Fairfield was suddenly seeing applications for upwards of 1,000 new units of housing. That can put a big burden on the folks downstairs in the land use office who have to process those and schedule all the hearings and everything. But that's one of those sort of immediate things that can happen when you apply for one of these moratoriums.
I have a question.
Sure.
So before you proceed, just this kind of introduction. What we're talking about here is an unintended consequence of the statute 830G, which allows something that kind of amounts to a free pass for developers should they be rejected for any kind of affordable housing or something that's labeled an affordable housing project, which may not actually have the spirit of being an affordable housing project. Is that correct?
Yes, generally, except the only thing I would disagree with is that it's an unintended consequence, because the state specifically crafted this law to create this situation where developers wouldn't have to come in and strictly comply with the zoning regulations. The spirit behind it is it's supposed to make it easier and more economical for developers to build affordable housing. So if you don't have to hire all the experts that you need, to satisfy all the requirements in the regulations, or you have the flexibility to build more densely, so you have more market rate units, so that helps make the building of affordable ones more economical. So the idea is that idea that they can kind of get a free pass on the zoning, that was intentional in the law. And it's designed to make it easier and less expensive to build affordable housing.
If that was baked into the legislation, doesn't that kind of undercut the entire enterprise? I mean, I'm not asking you to guess at the minds of the legislators, but it just seems like they created a backdoor through which all this could be circumvented.
I guess I'm not quite sure I followed that.
All right.
I'm sorry.
If you wouldn't mind to dabble in a hypothetical.
Sure.
All right.
Sure.
Someone wants to build a structure that doesn't, on a lot that is not permitted. Zoning says you can't do that for obvious reasons. This developer comes back with a new plan, which is very similar, but says affordable housing on it, or has some kind of attributes baked into it. Now, if it is rejected by zoning, it precipitates this whole legal matter with a really high bar for the town to get over. So, in effect, a tenacious developer could find a way to circumvent any denial through zoning.
As long as they're proposing affordable housing, I suppose that is true. It would have to meet the statutory definition, so at least 30% of the units have to be deed restricted, or the rent has to be restricted to folks whose income is below a certain threshold. So there's, I believe it's 40, 60, or 80% of area median income is what we typically are looking at. And within that 30% mix, and I apologize, I can't cite the exact number for you, but
okay.
There's another percentage mix of those affordable units. Some of them have to be towards that lower income bracket, and some of them can be towards the 80% bracket. So the key thing with any of these applications is that although they're circumventing around your regulations and building maybe where they otherwise wouldn't be able to, or density that they wouldn't otherwise be able to get, the town is still getting those affordable units, and that's their key to the door. If they're not proposing affordable units, then they can't get through that door.
So perhaps this is a way to say that your zoning laws are being too restrictive and that there needs to be this affordable housing so it outweighs your particular zoning board's interpretation.
Yeah, I would say that that's a fair assessment. It's just,
So the moratorium is, what's the length of time for that?
sure. That's a perfect segue to my next set of notes here. So the moratorium suspends that appeals procedure for 4 years. And then at the end of the 4 years, if the town wanted to, it could apply again. And there's some rules that are a little bit different the second time around when you apply. So time-wise, so you apply for your moratorium. The state has that 90-day period. If the state doesn't act within 90 days, you get a provisional moratorium, and that stays in place until the state makes a final decision. So if the state ultimately ends up granting it, then your provisional just becomes a permanent one, or permanent for 4 years. And then you could end up losing the moratorium if the state decided that some of your units didn't count or something like that, and then they would deny it, and that provisional moratorium goes away. But if you get the moratorium, it's 4 years.
And then, but if after doing a review, which is the zoning commission is trying to do of some of the regulations they already have, and taking a look at other factors, they could lift the moratorium before the end of the 4-year period.
Not as I understand it.
Okay.
So the moratorium is something that is issued by the state.
So it would
And
be obligated for the 4 years.
yeah, and I guess I'm sort of thinking this through a little bit here. I think once you have that ruling from the state, the Superior Court, which is what really drives all of this, is what happens in trial court. The judge would be obligated to apply the statute the way you have to when there's a moratorium in place. The town wouldn't have the option. We'd have to wait, for 4 years.
So just under the 830G, if a developer brought something forward and the zoning board denied it, right, then what they would have to do in order to prepare in case it gets appealed to court is be very clear as to why they are denying it and make sure it comes out of the record. Is that correct?
The zoning commission?
Yeah, the
Yeah,
zoning
yeah,
commission,
yep,
okay.
yep. That's what we tell them, is they have to specifically identify what it is they're relying on in the record. It can be multiple pieces of evidence or testimony, and be very clear about how that ties into, that overriding substantial public interest in health and safety, and explain on the record why they think that health and safety concern overwhelms the need for affordable housing in that particular instance.
Got it. Okay, thank you.
So there's 2 different pathways to getting a moratorium. The first one is the one that's probably familiar to most people. It's where the town hits a threshold of having 10% of our housing stock in town be considered affordable under the statute. We do not qualify for that. At the last check, I believe we were about 6% affordable in our housing stock. So we have a ways to go on that. The second pathway that can get you there is to collect a certain amount of something called housing unit equivalency points. So they call them HUE points. And this is the approach that we would be taking if the town decides to apply. So the HUE point system awards a point value to different individual housing units. So if you have an apartment complex with 50 units in it, each one of those units would be awarded a point value somewhere between 2.5 points or 1/4 of a point. And the point values are assigned based on various factors or circumstances of the unit itself. So the statute looks at what is the income restriction, if there is one. Ones with lower income restrictions, so 40% of area median income, are going to get a higher point value than one that's at 80% or at market rate. And they do give the towns credit for the market rate units as well, but they receive about 1/4 of a point. And they also look at whether the housing unit is owned by the occupant or is rented to the occupant. The affordable housing statute puts limits on the sale price that you can have for owned units or the rental rate for rental units. And so what the threshold for qualifying through this pathway is different for every town because there's a statutory formula that you have to apply, and you have to look at the housing stock as reported on the most recent U.S. Census. And so crunching all those numbers, what we came up with the land use folks downstairs is that East Lyme needs about 222 HUE points to qualify. And if we just look at Deerfield Village development and 38 Hope Street, or Seaside Village as some sites called, we can get to that threshold to apply if you decided that you wanted to do that. And there has been a change in the law that applies to a second time around application. So I'm highlighting those two developments because we're confident that we can produce the documentation that we would need to support the HUE point calculation for those developments. Some older developments are a little bit harder to find the records. They've been lost over time, things like that, and so things would have to be reconstructed. But we would only apply if we were going to citing those two developments, and any other HUE points that we might be able to claim right now, we would keep in reserve. So if you wanted to apply again in 4 years, you'd have an additional bank of HUE points to use. So anything that's included in a prior application can't be recounted. So that was a change in the law recently in the past year, but that's just sort of the behind-the-scenes mechanics of what would be happening there. So the application process itself, the state law places the decision of whether to apply exclusively in the discretion of the first selectman, and he has invited me here to make the whole board aware of the situation, and so that you can have a voice as well. When I held up the Waterford application, it requires a lot of documentation. And so the first step is to put all that together. We have a lot of it ready to go, and we just need to put it into the format that would be required for the application. But once we have a draft, what happens is the town publishes a notice of its intent to apply in both the local paper as well as the Connecticut Law Journal. And that starts a 20-day public comment period. So for 20 days after publishing the notice, the town has to accept any public comments it receives. The citizens can trigger a public hearing on the application by gathering a petition with 25 signatures on it. And it's interesting, this board has the option of either holding that public hearing itself or asking the zoning commission to do it. Once you get through any public hearing and the public comment period, the town has to look at the comments it's received or the testimony it got at the public hearing and come up with responses to anything that's worthy of a response in that record. And then that gets added on to the final application that's submitted to the Department of Housing. And so once it gets up to the Department of Housing, we have that 90-day period I've mentioned a couple of times where they can ask for more information. But if they don't decide within 90 days whether we get a moratorium, then you get a provisional one until they issue a final decision. And so we started to talk a little bit about anticipated consequences or effects that we might get from having a moratorium. And I always mention, as we've already talked about, that 90-day window as being sometimes attracting more applications under this law, which is sort of the opposite of what the town would probably be trying to do. But at the exact same time, we didn't see that in Waterford. So you just never know what will happen during that 90-day window. But that's sort of the most immediate effect. After that, the most immediate effect is that when an affordable housing application comes in, the town treats it just like it would any other applicant, any other application. So, like I said at the beginning, this isn't a moratorium on affordable housing itself. So people can still propose housing that qualifies as affordable housing under the statute. They just don't get the special treatment. So the town can strictly apply its regulations. And the benefit to the town on that is that it allows, the town to stand by its regulations and uphold them, but also for folks who are living or working or considering buying property in town, they can look to the regulations and be a little bit more reassured that what they see there is really what might happen next door. That someone can't use 8-30G to build something unexpected next door, that sort of thing. But there are some potential drawbacks as well. So as we were talking about before, the point of the law is to try, of the affordable housing appeals procedure, is to try to make it easier and more economical to build affordable housing. So you can reasonably expect that if you did have a moratorium, you'd receive fewer applications for affordable housing because it's going to be more difficult and expensive to build them. Over time, you can kind of see there would be a ripple effect from that. So most likely you're going to see market rate housing continue to be built while there's less affordable housing coming online. And over time, that will decrease the affordability of East Lyme in general and could price some families out of the town. The other thing to be aware about that is, I mentioned before that the state has set that goal of every town having 10% of its housing be considered affordable under the statute. If we have a moratorium, we're still subject to that. We're still supposed to be working towards it. And as we have that moratorium and fewer affordable units are coming online, but more market rate are coming online, we're going to slowly drop further behind on that 10% goal. So right now, we're at about 6%. It might be a little bit higher, a little bit lower. The most recent count was in 2021. But you can likely see that to be going down. So in the long run, over the course of the moratorium, it could make it harder for us to meet that threshold goal, as well as potentially making it harder for us to meet another HUE point application for a moratorium a second time around. Nobody can predict with certainty what exactly will happen during a moratorium, but I think these are commonly seen effects, and they're just sort of a logical follow-through from making these large projects have to comply with all of the zoning regulations and have to bring in all the technical experts you need and consultants to be able to satisfy regulatory requirements.
Could you tell us how many towns have met, towns that are roughly of our size, not cities, have reached the 10% threshold?
I don't have that figure right off the top of my head, but I can tell you it's not many. It's a difficult thing to do, especially for towns that don't have sewer systems, or perhaps don't have them throughout their entire towns. These large apartment complexes tend to need sewer facilities. So that's the rough outline that I have for the board tonight, and I'm happy to try to answer any other questions that you might have.
I have a question which is probably deceptively simple.
Sure.
You've done a really great job outlining how we would do it, providing us with examples. I don't think I ever really heard why. Why would we do this? Other than reassuring people that what they want built next door will be built next door.
Yeah, that's a good question. So I think the attraction for the zoning commission when it made the recommendation is, perhaps twofold. So our member of the public here mentioned that someone on the zoning commission, when they were discussing this vote, commented on the fact that they don't like being dictated to by Hartford. And in the zoning world in particular, there have been a lot of zoning reforms that have come down from Hartford that have forced change on towns. The idea of zoning is it's supposed to be local control, and we're, as a community, supposed to be determining what we want built in various areas of town. And something like 8-30G, it's a state mandate, and it just sort of takes that authority away. And so the zoning commission feels like by getting a moratorium, they're getting control back in a way that they haven't under these rules. And so I think that's the attraction for the zoning commission, that they can go through the effort of writing zoning regulations and then be able to expect that applicants are going to have to comply with them. I think that's the main attraction for them.
I don't want to put words in anyone's mouth, but it sounds like you're saying that they don't like following the law, so they want to circumvent it?
No, I wouldn't characterize it like that. I think the way they're looking at it is they have written what the law is in town by writing these regulations, and that their view is that here come these developers invoking this statute, and now they don't have to follow the black letter of the law that everyone else does. They're just getting a free pass on that because they're proposing affordable housing. And none of us sitting here right now have any vote up in the General Assembly. But one of the criticisms of 8-30G over the years has been that it doesn't effectively incentivize affordable housing. So, I mentioned before that to qualify as affordable housing, you simply have to propose a certain percentage be affordable. A lot of housing advocates say that that 30% threshold is nowhere near high enough. And I think a lot of towns would be happier to have 8-30G apply to them if they were able to get more bang for the buck out of it. And the developers have to build more affordable units in order to get this special treatment.
So
but that's just not the way the
The
law
appeal
is
to
written.
zoning is a 4-year reprieve so that they can flex their collective local control muscles. Is that the motivation?
I mean, I guess that's one way of saying it. But you have to think too. Zoning happens over a long period of time. So a 4-year period. I mean, just think about all the changes maybe we've seen on Main Street over the last 4 years. And then if you stack up multiple periods, it gives the zoning commission more control to shape development in town, which is what they're supposed to be doing.
Okay.
May I just?
Sure.
So I'd like to just suggest that maybe members don't create some sort of narrative here of what their perception of what this might be, or calling it something. I think that the zoning committee is trying to come to some sort of solution to some of the challenges, and correct me if I'm wrong, this is what I'm getting from it, that they're having, right? Because when somebody's putting in an application, I think it's actually them that are trying to misuse the law, or trying to push something in on a town underneath this camouflage of affordable housing. Is that accurate or no?
Yeah, I mean, to be absolutely honest,
Please.
I could see it argued either way,
Okay.
and I have seen housing advocates and
Right.
zoning reform advocates argue it both ways. I guess I should say that I don't know what was in the head of any particular member of the zoning commission when they voted for it, and they actually took that vote at a meeting that I was not present at. They had me at the meetings where they wanted to ask me questions, and then they wanted to have their deliberation on their own. I guess one historic example in town that might help sort of illustrate this is, I want to say this was maybe 10 years ago. There was an application for one of these affordable housing developments that was proposed in an industrial zone, and that is typically one of the exceptions to 8-30G, is that you can't propose housing in an industrial zone unless the town already allows housing in the industrial zone. And so the town denied it because this was being proposed in an industrial zone, and there was no clear housing permitted in the zone. But then when it got up to the trial court, the court looked at the regulations and said, well, you do allow nursing homes here, and we're going to call that a residential use. And so because of that, the zoning commission was overturned, and eventually that project became Rocky Neck Village. So that's sort of the origin story there. And so you look at where that development is, you wouldn't necessarily drive by and say, oh, that's an industrial zone, but the town could have seen industrial development in that zone, and that was what the zoning commission had identified it as what it wanted to go there. But due to this law, we have housing there. And so it really just depends on your perspective about, is that something that is more desirable than industrial development. It's a matter of perspective, I think.
So now my question would be, I think that it's identifiable that there is a need for more affordable housing across the entire state, right? So by putting in for this, it doesn't necessarily mean that someone can't put in to build affordable housing here. They still can.
That's right.
Okay.
Yeah, and the typical format that people think of affordable housing in is, a high-rise, 50, 100-unit development. And that's not always the way this presents itself. So I've been involved in applications in North Stonington, for instance, where they were building 2 units, and they were single-family homes. Waterford has one up in Quaker Hill that is being appealed in court right now, but they proposed a mix of single-family homes and duplexes. So it's not always the high-rise apartments and that sort of thing. And so what you may see with a moratorium is potentially more of that sort of project rather than the large-scale projects.
Okay, because I think that, from what I've heard, right, so correct me if I'm wrong, but there's been a challenge also with the availability of water and sewage here. So, and I thought that was part of some of this challenge, not necessarily whether or not wanting or inviting or having the ability to have more affordable housing. It's, can we keep up with that? I don't know. So that's why I'm bringing it up. And this is what this is for tonight, right? To have these discussions.
So when we're ready to have our discussion among the board members, I'd like to be heard first, as zoning is my ex officio.
Okay.
I've attended all of these meetings. I think I have a good insight on their intent.
Okay.
And
Thank you, Rose.
so,
And
Attorney Blaisdell has been very helpful.
I appreciate it.
And,
Okay.
but I think among ourselves,
Okay.
we know people that we're talking about.
I got it. Okay.
I was
And-
actually going to bring up the issue about the sewage.
Okay.
Yeah, that when we had our discussion.
if I may make one suggestion, something that the board may want to look at is the town does have an affordable housing plan where we kind of set out our policies of how we're going to try to work towards that 10% threshold. And so that might be something that the board finds helpful to look at. And I could forward that to Sandy to distribute.
Okay. Thank you.
Yeah, that would be great. Thank you.
Thank you.
Any other questions? Okay. This is
you
very
so
helpful,
much.
thank you.
Yeah, thank you so much.
And my understanding is you're going to stick around for our executive session to help us.
I am, and I can also give you comments on the Coastal Resiliency Fund if
Yeah.
you feel you need it.
Yeah, that's great. Great.
Okay.
So why don't we discuss this? See what we think. Roseanne, if you like.
Okay, so zoning commission has been my ex officio forever. So although I have missed a few meetings, I've been up to date with all of their minutes and familiar with all of the people that serve on the board. And this wasn't an easy decision arrived at. They've worked on this for 2 years. And in a simple term, this is not to deny affordable housing forever. They're asking for some breathing time to review the regulations, to see if they can be improved, to take a look at our basic infrastructure. What's available? What can we support without adding on additional services? Do we have the ability, our environmental policies strong enough to support affordable housing in some of these marginal areas? What about our water? That is not an unendable supply. So this was not easily arrived at. There were still people that were questioning at the last meeting before the vote. And finally, they all agreed that this was the intent, to prevent or to protect land that should not be built upon, rather to think of it in those terms rather than denying affordable housing. This is a 4-year moratorium. Most developers couldn't get a project up and on the ground in 4 years. I would be surprised if they wanted to extend it beyond the 4 years. But I can't predict what they would do. I think that many people are still confusing affordable housing with low income.
Yes.
What we really need is a few low income units. Many of those people who earlier in our term who came and were brokenhearted about being forced out of their their habitat, many of those people couldn't afford affordable housing. I'm not sure I could afford affordable housing. So in some cases, that's a bit of a misnomer, because many people confuse the two. So affordable is not low income. So I think overall, I don't want people to feel that this was a decision that was easily arrived at. And there were still some holdouts as of 2 meetings ago who wanted more time to reconsider, to think about it more thoroughly. If we were talking about banning affordable housing, I think that that would be quite different. And I think that it's unfair to say that we do not want affordable housing. We want affordable housing in the right places and not to have it dominate, as some people have said. It's not so much about what's next door, but to dominate the landscape. And do we have, for this kind of intensive housing which follows, do we have the infrastructure to support that? So I think that the Zoning Commission has worked very hard, very thoughtful. This wasn't an easy decision. It has the support of the zoning enforcement officer, and I think that we should support our locally elected zoning commission, support them for what they've asked for, breathing time. And we can't make every decision based upon, oh my God, we're going to be sued. Let's do the right thing. And if the developers can't live with it, oh well, they'll sue us for something else. So, there you go.
Thank you for that, Roseanne.
Thank you,
That's
Roseanne.
exactly what I needed to listen to and hear her perspective on that. Thank you.
Jason, did you want to comment?
Yes. So when I moved to East Lyme, when I first moved to East Lyme, I lived in the industrial zone up the way here. And that's where I started my family. That's where I got married. I feel really good about that place. And there were units within there that were described as workforce, which I think were a euphemistic way of saying these are affordable housing units. And the people that lived in them became my friends and neighbors, and I felt really great about that too. And when it came time to get involved with municipal politics, I got elected to planning, and I was one of the people that helped create that affordable housing plan, and I did so with great pride. So I see myself as sitting kind of in the nexus of this discussion in kind of a very personal way. And I want you all to know that I'm not creating a narrative or trying to make a decision before we even have a discussion. I think I'm a pretty open-minded and principled guy and would be happy to listen to reason. I'm just, I'm not feeling like anyone has really sold a moratorium. I know people in this community who I really respect and admire have proposed the idea and said, it's a great idea. And I say, oh, well, you know, I respect and admire you. But I don't think it's really been sold. So perhaps the next step is to hear directly from zoning. I don't know if that's out of order, or what would happen next. But I just feel like once you explain to me that no, the legislators put this mechanism in because the need for affordability is so great that there has to be something that kind of forces it onward. And people in this town are coming to us, their local elected leaders, and begging us to do something to make this town more affordable. And I feel like I don't want to adopt a position right now, but I guess I would end by saying I don't feel like anyone has sold the idea to me yet, and I'm completely open and willing to listen and entertain the idea. But the answers to the question why we would do this or why we wouldn't, well, why we would do this, why we would impose a moratorium, they seem, I'm sorry, they just seem flimsy at this point. So if it could be explained to me in a more personal way, not personal way, a more robust way, I would appreciate that.
Thank you, Jason.
Yep.
Yeah. Dave, what's your feeling?
Do you want to go next? I need to. I'm
Okay.
formulating my ideas.
Candace?
Well, I think that we're learning a lot. I think that we do have specific challenges here in East Lyme. for affordable housing and the challenges that the zoning committee has been facing. I'm more than willing to listen more if you feel you want to bring someone from the zoning committee here to speak on it, to maybe give a stronger, more robust presentation or information for
Perspective.
Jason perspective, for sure. At the end of the day, I wanted to try to make good decisions for our town, and make it affordable and make it a nice, wonderful place to live. But I do recognize that we do have challenges, and that there are specific challenges on other commissions and committees. So I appreciated the comments from Roseanne, for sure, coming directly from that committee, and kind of what has led us here. So I certainly don't have a yay or nay at the moment, but I understand where this is coming from, and the possibility of getting some breathing room for 4 years. I don't necessarily think that it is shutting the door or limiting affordable housing here in East Lyme, but I do recognize that we have some internal infrastructure challenges for accommodating certain things and coming in, and I'm willing to hear more and discuss more, for sure.
Thank you.
Tim, couple questions. I've sat in a couple zoning meetings too, and they were getting a little bit contentious, meaning that it's a way for the contractor to build a lesser house. For example, the people that are on the board were saying, okay, we like it, but we'd like to have you put a sidewalk in to go and buy for bikes or whatever. And the lawyer goes, we don't have to do that. And he goes, okay, we'd like to have, it's going to have 4 bedrooms or 3 bedrooms in these condo units. And that means it's going to be kids, so we'd like to have a bus stop out front where the kids can be in shelter. And he goes, we don't have to, don't you understand the law? We don't have to do that. And he goes, okay, what about a playscape in the back where the kids can be safe away from the parking lot? Because the one I went to do, the kids are all out in the parking lot. We don't have to do that. You got to read 30G. It doesn't say anything about us having to do that. And I felt that was a little contentious, meaning that, okay, and I understand the margins have to be kept in a certain way too, that they're handcuffed by keeping it affordable, truly affordable. That's one thing that I saw some contention there, and it's met some resistance. What are the rules once you buy a condo that qualifies as affordable? How long can you hold it, and what can you sell it for? Are you allowed to make money as an investment by buying on the cheap, okay, and then all of a sudden making some good money on it and selling after to be the comparable to the unit next door that's not affordable housing?
So
You're saying build it for less expensive and then sell it. Is that
Right,
what you're saying?
and then when
Flip
the
it.
time is up to qualify for that window of affordable housing, and Ann has a house that's not affordable, but the unit next door is affordable, because it meant if there's 30 units, so let's say there's 4 units that are affordable, does she coattail the price of that unit?
yeah, that's a really interesting question. So I think maybe I'll start with the first piece of what you said about there being an impression that these affordable units are less quality. And what the law says is that you're not supposed to be able to look at the unit from the outside and tell whether or not it's one of the affordable units or
This
not.
is about amenities, so, okay.
Yeah. And then when you get inside, you might have, not as high a level of finishes, for instance.
Got it.
Now, let's say it's an owned unit, okay, so the statute dictates the rules, the formula by how they calculate, allowable maximum purchase price, and you have to comply with that to stay in compliance with the affordability laws. And every affordable housing complex in East Lyme has what's called an affordable housing plan, and there's an administrator who is supposed to be tracking the sales, helping to market them, and making sure that all the sales are being done in compliance with that. And so what your allowable sale is going to potentially be changing over time as area median income increases. So because everything is kind of calculated off of that. So I can't give you a specific number about what the value is that you could sell for, but for instance, let's say you bought an affordable unit and you came in and you took out, you know, the cheap counters that were there and put in, you know, whatever, the highest that you could afford, the nicest ones you could, no matter how many improvements you make to the inside of that unit, when you go to sell it, if it's still within the affordability period, you're subject to selling it within the restrictions of the Act. So you could lose money.
Does resale have to be, again, as an affordable unit? Let's say in 8 years.
Yeah, exactly. So so that was another piece of qualifying as an affordable unit, is that it has to be restricted for a 40-year period. So
40 years.
yeah,
Oh,
so
okay.
if you were to buy it and hold it for 40 years, then you could sell it at market rate.
Okay,
Yeah.
that's what I
Yep.
need.
Okay.
Yeah,
Yeah.
40 years.
Sorry.
Thanks, Tim.
Sure.
I'm good, thanks.
You did? Okay, so, I guess I feel like, what was it was saying? Don was saying that, you know, sometimes the developers don't seem to have to follow the regulations. So I can understand where zoning came through and said, yeah, we want to support a moratorium because, you know, we support these regulations, we put these in place, and now the developer can say, yeah, no, I don't have to do that, I don't have to do that. And I think, you know, it's a struggle for zoning because they're looking at zoning in the whole town. I think a 4-year moratorium, I think I would be in favor of it. And I think that, you know, when you're talking about affordable housing and, you know, it's really not affordable. I think what you need is like low income housing here. You know, that's kind of really what we need. And I think maybe affordable housing might be a misnomer. And the other thing I was going to say, just based upon being on inland wetlands, when we made a decision on that, we had to be very clear and make the record clear for court. Actually, one of our decisions was appealed, went to the Superior Court. So I think that zoning probably does that anyway, and I think they need to continue to do that. And I would say that the town, Bill Mulholland, you know, really has to make sure that zoning actually puts everything on the record and draws everything from the record when they're making, you know, their decisions. And I think 4 years is actually, you know, in town politics is a very, very short time. So the other issue I had is, and I don't know how this works, I know this is something that if it goes forward, it's just the first selectman needs to sign it. I know we're going forward under the housing equivalency points, housing unit equivalency points, and I just didn't know the timing. So I know that some of the other members have said they want to have zoning come in and this and that, and I just don't know what time constraints we would be under if the first selectman decides to sign it.
There is no time clock on this. So in terms of the units that we can count right now, as long as they continue to have certificates of occupancy that are valid from the building department, then we're allowed to count them. When the clock starts ticking, I would suppose, is when the town publishes that notice of intent to file, because then you have to start making sure you have your public comment period open. But at this point, if this board decided it wanted to hear more information about it, there's no clock running at this point. You can take as much time as you want.
So once you put it in the newspaper and everything, that's when the 90 days starts running?
No, that starts a 20-day public comment period.
Okay.
So and during that period, the public could trigger a public hearing.
Okay.
This board could also decide to hold a public hearing on its own in advance of that, or after there's a draft application. You don't have to wait for a petition. But that 90-day window doesn't start to tick until you've actually filed it with the state. And that's the Department of Housing that we file it with.
Okay. Now, you also said that you have a lot of the information now. So let's say we do have zoning come in or we get other information, then would that make the work that either you or the land department had to do a lot more voluminous?
No, I don't think so. So actually, it's a good question because I did say that there's certain things that could add on to our application. And what I was referring to there is we have to provide the state with copies of any public comments that are submitted during the 20-day period. And if we do have a public hearing that's triggered by that petition, we would have to add on, public comments that were received or evidence that was received at the public hearing. They get appended to our application, and if there's things in there that the town needs to respond to, then the Department of Housing will be looking for the town to have written responses to some of those.
And is that something, what we would need to respond to? Is that something that, like, town council would say, this is something you need to respond to, basically? Or do you just respond to everything if there's public comment?
I guess it would depend on what the comments were. They're like, we would look at it as town council and advise the town, that it's absolutely necessary to respond to these things. But it is also possible that some of these comments are going to be of more of a political nature, and it would be a political decision about how and whether to respond to them, rather than a legal issue.
Got it. Thank you.
Thank you.
Now, is it possible to have a joint meeting of the Board of Selectmen and the Zoning Commission? Or another option is all of their meetings are recorded.
Yeah, I
Well,
was
that
going
was-
to say that too.
So, I don't want to interrupt.
Yep,
I'm
that's
sorry.
it.
My thought was, I thought a couple of options. So it seems like there is an interest in hearing more from zoning, am I right? So, what I thought one thing we could do is, we'll identify what meetings this was discussed at. Maybe you could help, Roseanne, tell us what meetings. We could on our own watch those meetings on YouTube to gather information and gather insight as to what their thinking is. It's almost like reading the committee notes in a statute, the same kind of idea. Or we could invite the chairperson to come here and representing the board and answer our questions and address the thinking of the board through the chairperson, who hopefully would represent the common thinking of the board. Or we could invite them, I don't know if we want to call it a joint meeting, but invite them to our meeting, and they could address us as a public delegation. So those are three suggestions. I don't know what the feeling is of this board, whatever we think is best. What's your feeling, McGoran? Would you rather have them, all of them here, or just the chairman, or we can just watch it on TV?
I think that perhaps I couldn't immediately identify what meetings.
Okay.
But that would be a possibility, and then have a couple of representatives come, maybe the chair and the secretary, or someone who would have them come to perhaps give some. But I think those meetings are pretty self-explanatory.
Okay. So
But
that's-
maybe watch the meetings.
And then see how we feel?
Yep, and then we could always invite them. I was, the board, however, was very concerned that there was a timeline for them with the moratorium, and yet Attorney Blaisdell has said there isn't, so.
So I'm going to rely on Attorney Blaisdell.
No.
Jason, what's your feeling? Which option?
I mean, if it's between watching 2 years worth of YouTube videos and having a conversation with some of my neighbors, I think I would prefer to have my neighbors come in and talk to me a little bit. But of course, I will watch whatever videos people recommend I watch.
There's only a few most of these meetings, the discussion hasn't lasted the entire meeting. So I will talk with the chair and see if she can narrow those down.
That's a good idea. Ann, what's your feeling? What's your preference?
I think that it might be important to look at the meetings only because you'll get to hear real time what the zoning board members were saying. If you have the chair just come and speak, she's not going to remember everything. She'll do the broad stroke. But I do think that it would be good also, besides looking at videos on our own, whatever, one or two, whatever is really relevant, then maybe have somebody from zoning come and, if we've already looked at it, then we can kind of hear from them. Yeah,
Okay.
so that's what I
Candace, what's
think.
your thoughts?
I would be in agreement. I think that we would all probably get a good perspective on just kind of looking back and listening on some of the meetings, and I plan to do so. With that being said, I also think that we'll get a tremendous amount out of having a couple of representatives come in. It allows not just the dialogue, but also the Q&A to really get a good feeling for, you know, kind of how they came to their decision, what they were looking for, and I think that we'll all have a better feel after that. And I think it's worth doing that. Also, it's a public meeting, right? So others can come, they can come and listen, and if not, then they may hear that this is something that, right, is being looked at. Of course, it's going to be out in you know, paper and that type of thing. But it would also give people the opportunity to look back and see that, you know, we've done our due diligence and kind of the questions that we're asking and really what we're looking for here, versus maybe being painted into a box with a narrative that maybe just doesn't fit.
Okay. Don, what's your feel?
I forgot his name, the gentleman of the delegation. What's your first name?
Joshua.
Joshua. I'm directing a lot of this towards you because you did a good job tonight, but I look at the moratorium as we're not stopping. We're handcuffed with sewer and water capacity.
Exactly.
Okay, so we gotta look at that too. So look at the 4-year moratorium as training wheels on a bike. Just gonna, till we get our balance and know what we're doing. It's not stopping anything. And so I'll go either way as far as how you want to listen to it, but I just want to still let him know that we're not stopping. We're not against affordable housing.
Yeah, I see that. Yeah.
But, okay, but the sewer and the water is a huge issue with everything we do around here right now.
So,
And that's it, thanks.
thank you.
Yeah.
So I think what I'd like to do is maybe Roseanne, you could work with Sandy,
I
and
was gonna suggest
If
if
you-
you don't give me some time tomorrow, but I can probably easily
Identify.
find,
I'll
through
come,
the minutes.
I'll come down.
And then I can do the videos and tell you exactly.
Which
what
ones?
I want.
That'd be perfect.
so why don't we do it that way, and then,
Okay.
I'll meet with you tomorrow.
Yeah, I'll be
and once we identify the relevant videos, and if you could identify those, just email that to all the board members. And then, if we get that, maybe over the next 2 weeks, we can find the time, maybe try to view those videos. And then at the next meeting, we'll invite a subset. We don't need the whole board, I don't think. Maybe we'll get the chairperson and maybe one other from each of the two parties, and have them come here, and we can ask some questions and really get a better sense. Does that sound like a reasonable approach to everybody?
Yeah, definitely.
All right, that's what we'll do. All right, thank you very much, Tim. It's a complex subject, no clear answer to me at the moment, but we're going to try to figure it out.
I
So.
wonder if Attorney Blaisdell has any further advice for us? Comments?
On that topic?
Yeah.
No, I think that's a reasonable approach. I guess what I was sitting there thinking about is we often tell the zoning commission that when members of other boards and commissions come to their public hearings to make comment, that we make clear for the record whether they're speaking on behalf of the commission that they're coming from.
Gotcha.
But I think here you're asking them to specifically appoint 3 people to come and address you, and so that issue is not really there. So.
Great,
Thank
thank
you.
you, Tim. All right, so now we'll leave that, and it was a great discussion, and that's how we should try to approach things, get it right. The next is a discussion on the creation of a coastal resiliency reserve fund, and we can all remember the seawall falling in a couple of years ago down at McCook's, and there is good reason to try to have a coastal resiliency fund, a reserve fund. So when those types of events happen, at least we have initially some well to dip into to help pay to alleviate damage. But the other reason for it is that because we're a coastal community, when we go to borrow money in the bonding process, that's one of the things that the lenders, bond counsel, wants to see is that we do have a coastal resiliency reserve fund, because absent that, we're going to get a lower rating, and it'll cost us more for money. So we don't have a lot of money in the budget this year to put into it, but the important thing is that we make a stab at it and we start it. So in order to do that, we have to create the fund. and there's a process we have to go through to do that. And it's referenced in statute 7-159D. I'll just read from my notes to Denise Hall. It provides that a coastal resiliency reserve fund may only be created by the Board of Selectmen if, the first selectman recommends creating a CRRF, and so I'm recommending tonight that we do this. And then after I recommend it, the next step is for the Board of Finance to approve the recommendation. And then this is the letter that I sent to Denise Hall as chairperson of the Board of Finance. So we've taken that step. And then it has to be recommended by them, and then it comes back to us, and we and then we vote on it to create the fund. So this is the first step in this somewhat cumbersome process, but you have the documentation here, and Attorney Blaisdell is here to answer any other questions you might have about it.
So
All right, this is one of my other ex officios. This is Commission of Natural Resources, and we got a grant to have a workshop, which unfortunately we had to have online, but to have input. And this was sort of like a mini college course on environment and environmental issues. And this was strongly recommended by them for exactly the reasons that have been outlined in the memo that we received. Also, it makes us better qualified for numerous grants, including the ones that we've worked very hard on from the state of Connecticut to achieve gold. We're now labeled as a silver community, but when you get the gold rating, that offers a lot of other opportunities for us as well. And this would count as points towards that.
Yeah. That's right. So I think it's a good thing. I think it's a necessary thing. So the first step is that I requested of the chair of Board of Finance, which I've done. The next step is for me to recommend creating this to the Board of Selectmen, which I'm doing tonight. And then the next step will be the Board of Finance vote to approve the recommendation on their May 14th meeting. And then we'll be back here on the 21st to vote. I'll present the ordinance creating the fund here, and we will vote on it. And then we would schedule a public hearing, and ultimately the goal is to get this to be an ordinance before the end of the fiscal year so we can put money into the fund. And that's why we're trying to really be very careful in tracking the dates.
Dan, can I ask? You
Yeah.
go ahead, Dan. I'm sorry.
just a quick question. I thought we were doing the budget. I thought Kevin Gervais said that we had already put money into a coastal resiliency fund.
We have money in the budget, but we can't really put it into the fund until we create the fund. So
Okay.
this is this is why we want to get it. We have money in this year's budget put
Okay.
into it, but unless we have the fund in place,
Is this the first year that we put money into this?
this will be the first year.
Okay, I guess I thought there was money in
And
it
then
from
next-
last year.
Well, there's money in it this year to be put into it,
Okay.
but we
all right.
can't put it into it
All right,
unless it
that's,
exists.
okay,
So
that's what I was.
we need a bucket to put the money in. And
Understood
this is
now.
the bucket.
Got it, okay.
And then we've also, in our budget discussions, there was another amount for the coming year,
Yeah, okay,
so.
got it,
Yep.
thank you.
But once it's created, we won't have this problem next year, we can just, and then eventually this, hopefully this fund will grow and we'll have a little bit of a reserve
Mhm.
in the event of an emergency, which is good
Yeah.
fiscal planning. Jason?
You answered my question.
I did.
Thank you.
Okay. Are there any questions of Attorney Blaisdell? Pretty straightforward? I mean, the process is really the confusing part. I'm trying to get all the dates right so we get this done before the end of June.
I think you're on track there.
I'm on track? I'm trying. That's about the only thing I'm on. Okay, let's see. All right, very good. So we've done that. The next is to appoint to the Board of Education representative to Cable TV Advisory Council of Eastern Connecticut. And I think we have let's see, a motion in here and a suggestion for appoint.
Move to appoint Catherine Steele of 23 Rose Lane, East Lyme, as the Board of Education representative member on the Cable TV Advisory Council of Eastern Connecticut for the town of East Lyme, with a term to expire on June 30th, 2027.
We have a letter from Superintendent of Schools, Jeff Newton, recommending and asking that we appoint Catherine Steele. Any, do I hear a second?
Yeah, we need a second. I'll second.
Do you have any discussion on this?
I think she's a good choice. She also has her own show, Stories Worth Telling,
Yep.
which is on a couple times a week. So she's very familiar with the procedures and what things we might not be aware of that would be available. So she's a good source. She knows a lot of people over there.
Agreed.
All right. So with that, all in favor signify by saying aye.
Aye.
Any opposed? Any abstaining? Motion carries. Great. We don't have any old business tonight. Do we have ex officio reports? Roseanne, anything?
I think I've said my piece for
Okay.
tonight.
Jason?
I do not have any.
Okay. Yep.
Okay, so I attended the library meeting the other day, and they're talking about doing let me see what this is, East Lyme Public Library commemorative gift policy. So people can name a room, they can donate books, etc., etc. Now, the issue that they wanted me to bring up was they also have something in this policy regarding memorial gardens or tree planting. And the issue came up that anything like tree planting or memorial gardens is outside the library, which is on property which is owned by the town. So they wanted me to kind of ask and say, is this something that they can actually put in this policy? Because, you know, they don't actually, you know, they're in the library, they kind of have jurisdiction over that space, but they don't really, you know, outside the library is where they would be, like, you know, planting these trees or shrubs or what have you in memorial.
And who is this that wants to do it?
The library. So, for instance, like Abe Fisher passed away. He was on the library board for many years, and so they want to, you know, plant a tree in his memory. And the issue is, can they do that? You know, they want to put up a commemorative plaque and
On town property that isn't their property.
correct. And I did speak to Marjorie Meekhoff today, and she was saying that the East Lyme Garden Club, I guess, was kind of keeping track of the plants and everything outside the community center.
Yeah.
And then I guess they basically gave jurisdiction for the maintenance of everything over to the pollinator pathways. But the town still owns the property, but they were just talking about the maintenance. So they kind of wanted to know if it's something that they could put in the policy or not, and whether that was something that, you know, the Board of Selectmen would approve.
So let's do this. Can, since it's not an agenda item,
Yeah.
why don't you have you or have them send me or send all of us the
Yep.
policy, or I'm willing to look at it first, and then we can put it in the packet for the next meeting.
Okay.
And I'll try to get an opinion. If I can't figure it out myself, we'll get an opinion
Okay.
to see if that's something that I should or can do.
Okay, great.
So I was actually there today, delivering lunch to the workers there who are working on the garden at the back.
Yeah.
Yeah.
And so they're putting plantings in there. I think the issue is that now they want plantings that are dedicated to specific individuals.
Correct.
So they already have permission to put in the community garden, which is underway, and so I think that's the distinction.
Yeah.
Yeah, well, yeah, it's not something we can, up the top of our head.
Yeah,
I think
no,
we
I
need
just
to look
wanted
into it a little
to
bit.
bring it up. It
I'll
came
talk
up
to-
with,
I'll talk
yeah.
to Joe Bergaw, Jerry Loken, and if I think we need a legal opinion, we'll get that, but,
Okay.
let's just, let's look at their
All right.
policy and see if it's,
and I'll
something.
pass out the policy.
Yeah.
We'll make sure it gets to Sandy.
that's great. Thanks for
Okay.
bringing that to our
Yep.
attention. Appreciate that.
That's it. That was it for me.
Great. Anyone else? No, we good? Yeah. We're good, okay. And I don't have any ex officio tonight. First Selectmen's report, just a couple of things. One of the things that's been a thorn in our side here a little bit is we've had the town audit, which, it got behind. I don't think we've been on schedule for 13 years and filing it timely. And we're finally, with Kevin Gervais' help and his staff, we're finally getting to the point where I think in the next year we'll be able to be filing these audits when they're supposed to be filed. And every time the last two that we've done, we've probably gained another, we're about 15 months, it seems, behind in the cycle. So we're getting down to about 13 months behind now. And I had to go testify today up in Hartford with Kevin, what they call the Board of Regents. And it went very well. I explained to them that we're very sensitive to their needs for timely reporting, and I get it that they have to report to someone further up in the chain in the state of Connecticut, and delinquent reports delays their reporting, and so we're focused. We've improved the last two audits. Now this last one was very rigorous, and a lot of hard work was done, but that really has positioned us now for the 2024 audit. Once that starts, we've got a lot of the legwork done, so we're going to really be able to gain time and efficiency. So I wanted to report that we went to that meeting, testified, and it went very well, and I think we're not going to be on what they call their watch list, where they really get right down inside the town, and we don't want that, and I think they're saying that we're doing the right thing. So that was today. The elephant in the room is that we've had two police officers retire in the last week, and unfortunately had to put the deputy fire chief on administrative suspension. I will only say at this point that, moving forward, we're going to try to restore the confidence that the public has in public safety, the fire department, the police department, and we're going to work really hard to achieve the guardrails that we need so people can feel confident that the people that work for this town are being hired in the proper way. And I want to do the best job that I can to improve that and establish the right process to do it. So we're very cognizant of the concerns of the town, and I want to assure everybody we're going to do our best. So that's my comment on that. I'm not aware of any communications.
Can I say something?
Yes, of course.
So I don't know if everyone received this. I received an email from Carol York, and after going back and forth with her on the matter, I asked if I could read something into the record about ALS Awareness Month. That wouldn't take away from the meeting. So in addition to being National Military Appreciation Month and Asian American Pacific Island Heritage Month, May happens to be ALS Month. I invited Miss York to come and say her piece at delegations. Being diagnosed with ALS makes it difficult for people to move around and say things, so when she declined, I said I'm not going to press the issue, but I would read part of her letter. So, ALS is known as Lou Gehrig's disease, a devastating and fatal neurodegenerative condition. It progressively destroys motor neurons, leading to complete paralysis and, in most cases, death within 5 years of diagnosis. There is no cure. How can that be when Lou Gehrig was diagnosed with the disease in 1939? Military veterans are disproportionately affected by ALS. Multiple studies show that they are significantly more likely to develop and die from this disease than the general population. But regardless of who contracts the disease, it's awful for the patient and their loved ones to endure. While their minds remain sharp, people living with ALS lose the ability to walk, talk, eat, and eventually breathe. As their independence fades, they often rely entirely on caregivers. In advanced stages, round-the-clock care becomes essential. To truly confront ALS, we must raise awareness and ensure policies reflect urgent needs of those living with the disease. Increased advocacy and legislative support are critical to advancing research, easing the burdens on families, and ultimately finding a cure. So I just wanted to put that out there, and our heart goes out to Ms. York and anyone in your life who might be affected with ALS.
Thank you. It's
Yep.
it's an important concern. Thank you. I want to make sure I said the deputy fire chief in my comments before. I'll make sure that I said that. Okay. All right. Any other communications that anyone wants to share? I don't see any additional public comment. There's no one else in the public here. So the next step is to go into executive session. Can I hear a motion to go into executive session?
Move to enter into executive session for the purpose of discussing public safety personnel at 8:25 p.m.
Please to include the town attorney.
Oh,
Yes.
sorry, and it will include Attorney Tim Blaisdell, the town attorney.
Thank you. Do I hear a second?
I'll second.
All in favor?
Aye.
Opposed? Abstaining being none, we are now in executive session. Okay.
I'm not even
And
sitting.
it's, started 9:22.
Okay, the board entered into executive session at, I forget what time, I think it was 8:17 p.m. They returned at 9:22 p.m. and it was stated that no formal votes were taken. I'd like to move to adjourn the May 7th, 2025 regular meeting of the Board of Selectmen at 9:22 p.m.
Do I hear a motion? Do I hear a second?
Second.
All in favor?
Aye.
Any opposed? Being none, motion carries. We're adjourned.
Everybody's signed.